Sarah, are you ready to go? Okay.
Recording in progress.
Good afternoon, everybody. Thank you for being here today. This is the first meeting for the subcommittee on the worker continuation of care. It is Thursday, August 25th, 2022, 1 p.m. meeting start time. Before I turn it over to Matt and Sarah, who graciously are the official members on the subcommittee, although we do have other Black members here, I just wanted to do a couple of housekeeping guidelines for today on this. For those who don't know me, I'm Teresa Van Winkle. I am MLAC, the administrator for MLAC. As indicated on the agenda, which if you don't have in front of you, in the chat is a link to that and a memo from the MLAC co-chairs about the subcommittee. The meeting will be in a roundtable format. Everybody who is here at the meeting has an opportunity to speak. If you do want to be in the queue, please raise your hand with the raise hand feature, or if that is disabled or you're having technical glitches, please indicate you want to speak in the chat. If you're participating by phone, please let me know via sending me a text. And my cell number is 971-600-4595. And my contact information is also on the main MLAC webpage, which you can see from the link in the actually, you don't have that, so never mind on that. As indicated at the beginning of the meeting, this meeting is being recorded. All chats also are considered public record and are downloaded upon the meeting's conclusion. So just to get that off the board. So I think that's all I have on my end. So I will turn it over to Matt and Sarah, and we'll start with introductions and go from there.
Okay, I am Sarah Duckwalt. I am the management representative that is appointed to this subcommittee.
Thanks. I'm Matt Calvia. I'm the labor representative appointed to the subcommittee.
And I'll go through the MLAC members that I do know that are here, and then we'll turn it over to the rest of the other participants here. So I will start with John.
We can't hear you, John.
But you can hear us, John. Okay. All right, we'll move on. So it's John McKenzie, management member. Oh, okay, thank you. We'll figure it out on our end if there's anything going on with your connection. We'll turn it to Margaret.
Thanks for the welcome.
And Scott.
Thank you, everyone. Scott Strickland here by video.
And Andrew is, Director Stolfi is also participating as well on that. I will then turn it over to, let's see, I'm looking here at the squares, making sure that, I'll turn it over to Elaine from SAFE, and we'll introduce the group from SAFE.
Hi, yes, Elaine Schooler. I'm a trial attorney at SAFE Corporation.
And is there anybody else from SAFE? Oh, hi, Kevin.
Hi, Kevin Barrett from SAFE.
Okay, and from Travelers Association.
I'm Rod Ewing, and I'm with Travelers.
Keith Simple with Oregon Travelers Association.
Hi, Keith.
Giovanna Patrick with Oregon Travelers Association.
Hi, Giovanna.
Hi.
Okay, I'll turn it over to DCS staff. We'll start with Sally. Unless I call Sally off guard.
My apologies, slow on the clicking there.
Well, I kind of surprised you, so let's do it.
Sally Cohen, Administrator of the Workers' Compensation Division. It's great to have everyone here today. Thank you.
I was told by Kara I don't need to call on her, but Kara Filsinger is here as well from WCB. Jennifer.
I have no idea if it came on or not. Hi, Jennifer Flood, Ombuds for Oregon Workers.
You're here.
Okay.
We see you. Hi. And see, and Maria is here as well.
Maria Venegas, and Jaylee Ladd Musgrove
Okay,
from our office.
hello. Let's see. Okay. And actually, before I turn it over, there's, so Dave Berenberg from SAFE is also here. Apologies, any glitches on our end for getting you into the meeting. I think he's still connecting, but he is here. Let's see. And then Dan Schmilling is also here from SAFE. Dave, can you hear us? Maybe. Just making sure Dave is connected.
Yep.
Okay, you're good? Okay. Okay, so I can turn over to Matt and Sarah. Do we want to go through and introduce everybody here in the room, or is there anybody here that's was planning on speaking, doing like in regards to the scope of the committee? Any ideas before we fully kick off the roundtable portion of the meeting?
Teresa, this is Sarah. I think we were hoping to just go through the charge as a continuation of care and make sure we all have a clear understanding of our scope.
Certainly.
And to make sure we stay within the scope in this meeting.
Okay. So, so for those in the audience, one of the meeting materials is a memo from the MLAC co-chairs that was issued on August 17th, which outlines which formally establishes the subcommittee. And within the memo is the charge, which I will read verbatim. Charge to the subcommittee. The subcommittee is charged with resuming discussions related to House Bill 4138 from the 2022 legislative session, as was agreed when the full committee recommended to support the legislation in February 2022. When workers who are off work or on modified work maintain regular treatment with their attending physician, they have more successful outcomes with their rehabilitation and return to work. When a worker and their attending physician are not maintaining regular contact or treatment, rehabilitation or return to work can be delayed while a worker receives time loss benefits. The purpose of the subcommittee is to explore solutions so that all workers are able to remain connected with their provider and minimize gaps or delays in treatment when they are off work or return to modified work. The committee today is, and there's a typo on the memo, today is the 25th, which is the first date of the meeting. So amongst the other key dates and deadlines have been established. The subcommittee is to report to the full MLAC committee on our standing meeting dates of September 22nd and October 20th, with a current deadline of November 10th, 2022 for final subcommittee recommendation to the full committee. And then in regards to the schedule of the subcommittee, other meeting dates are to be determined, but we are targeting the next meeting date to be on the morning of Friday, September 16th.
Thank you, Teresa. It's nice to hear that verbatim. And again, we look forward to continuing the conversation related to House Bill 4138 that we agreed upon in full to support the legislation in February 2022. So this is an exciting time for Matt and I to be part of this discussion. So thank you very much for that.
I think I'd add on the other guidance portion of that document that the scope of the subcommittee recommendations should be limited to the solutions that could be achieved within the workers' comp system, including proposed law changes, administrative rules, and other processes. So yeah, I'm excited to get to work on that.
And it's probably appropriate for me to also mention that if other topics that are outside the scope of the subcommittee do arise during conversations, it is the department's commitment to address those outside of the subcommittee. And so as those arise, we will work with the committee and with the individual stakeholders on that. So with that, let's see, I will turn it over to the two primary parties that are the catalyst for the subcommittee, OLA and SAFE. So I'm not sure who wants to begin discussing your portion. Okay, Elaine, go ahead, go for it.
Sure, I'm happy to kick things off. Elaine Schooler on behalf of SAFE, and I want to clarify too, this isn't just a SAFE issue. This discussion actually goes as far back as 2019, quite some time ago, when there were a series of time loss issues that were being raised by the trial lawyers. And from that flowed many discussions over the course of 2020 and 2021 with stakeholders from both sides. It wasn't limited to SAFE, there were other defense attorneys and employer representatives participating and engaged in time loss related discussions. Ultimately, that resulted in House Bill 4138, which made several changes in the area of time loss, as well as some other sections of benefits, such as overpayments and disability. With the time loss, two of the big changes were notice requirements being placed on insurers before there were an end to time loss benefits, as well as an extension of the time period for retroactive benefits from 14 days to 45 days. And part of those discussions over the course of those several years was this continuation of care in the arena of time loss benefits and ensuring workers are remaining connected with their providers throughout the course of their recovery. When we came to the conclusion of House Bill 4138 and putting forth our support for those changes, and the agreement was reached that we would revisit the continuation of care piece. That commitment was reinforced by the legislature and also from the MLAC members to pick up where those discussions left off, and so here we are today. I thought it might be helpful to just have a very brief refresher on time loss. So time loss is compensation paid to workers when they're unable to return to work due to their injury. This supports the workers during the course of their recovery so that eventually they can return to the workforce. And restoring workers physically and economically to that self-sufficient status in an expeditious manner, that's really one of the goals. It's actually in ORA 656012. It's a charge enumerated by the legislature that that's something that we're meant to work towards. Now, time loss, there are two types of it. We have temporary total disability, and if the worker is taken completely off work as a result of their injury while they're recovering, so they're not doing work of any kind. And during that period, time loss benefits would be paid to that worker. There's also temporary partial disability, where a worker is given some type of work restrictions as it relates to their regular job. Those could be physical or hourly, or a combination of the two pieces. And if an employer can accommodate those restrictions, then no time loss would be due. And if they cannot, or they can only accommodate a portion, temporary disability benefits would continue to be paid out relative to any wages they were earning, and if none were earned, then at the same amount as the temporary total disability. Now, for time loss benefits to flow to the worker, they must be authorized by an attending physician, and that authorization may or may not have an end date. Attending physicians are not required by statute or rule to include an end date on their authorization. And that when there is no end date, we call that an open-ended release. Now, when workers are receiving time loss benefits, the goal is that they are recovering from their injury. And a problem can arise, and we see it in our cases and claims, when workers are unable to maintain regular contact with their attending physician while receiving these benefits. And when there are gaps in care or contact with the provider, the worker's progress is not monitored, needed treatment can be delayed, work restrictions may no longer be appropriate if the worker is having trouble performing the modified duties, or the modified release is no longer needed because there has been improvement. Our goal for all of this is to help workers recover from their injuries and be able to return to the workforce. Ensuring workers remain engaged with their provider is really critical to their recovery. And setting some clear guidelines and expectations for both workers and providers removes ambiguity and confusion as to their role as the two most important participants in that recovery process. Now, as part of our discussions with the trial lawyers, the concept of regular and timely contact with providers when time loss is authorized in the arena of open-ended releases was brought forward to the Medical Advisory Committee. We call that MAC. Excuse me, MAC. MAC is comprised of providers from different specialties who operate within the workers' compensation system. And those providers typically meet on a quarterly schedule to discuss medical trends and other issues within their purview as it relates to workers' compensation and worker care. At that informal meeting and discussion, the consensus was that open-ended time loss authorizations were not a good idea. And in fact, some of the providers were surprised that that even existed in the system. The consensus was that regular contact between the worker and the provider was a necessary piece of that recovery, and without clear expectations, there can be breakdowns in that process. We would encourage the subcommittee to reach out to MAC and engage with them on this issue, as well as others who operate within this realm, such as the managed care organizations. Ultimately, we want workers to have access to benefits, receive timely treatment for their injury, and return to the workforce. We maintain that regular contact and treatment with their provider is the best method to achieve this goal. I'm happy to answer questions the co-chairs may have and appreciate the opportunity to present today. I know there are others who are also engaged and involved with our discussions with the trial lawyers who may have additional comments or thoughts to share too on this topic. Thank you.
Thanks, Elaine. So I will turn it over to Ola before opening up for others to speak as well.
Yes, thank you, Ms. Van Winkle. So I'm Giovanna Patrick. I'm a workers' compensation attorney representing workers. I am the co-chair of OTLA's workers' compensation section. So I think we need to acknowledge that there are practical, real problems with getting into medical care in this post-COVID world that we live in. The solution is not to force more appointments on workers and on doctors when the doctors might not have the capacity. This kind of goes to the last line that was mentioned in the charge, in that this might not be something that we can fix within the workers' compensation system, the greater problem of access to medical doctors. Now, these proposals are about doctor dodging, which in my experience is extremely rare. The proposed solution puts all workers and their families at risk of losing their benefits after 30 days, benefits that they're otherwise entitled to on accepted claims, regardless of how hard they try to comply, regardless of whether they go to all of their scheduled appointments. This hard rule, day 30, you're out of luck, makes no sense when we're talking about accepted claims workers who are entitled to these benefits under the rules. This puts the workers at odds with their providers and their providers' staff, and that can create greater problems and greater issues actually getting that care. So we're putting the workers in the position of demanding that their doctors give them a new restriction on day 30 on pain of losing their benefits. This is likely going to cause more doctors to get out of the comp system because, again, it's another requirement, another thing that doesn't make sense with their practice that they're being required to do because this is an injured worker. It may also cause doctors to dump patients who are being too demanding. It shouldn't fall on a compliant worker if the doctor takes a vacation or is otherwise unavailable or otherwise believes that it's not medically necessary to see the claimant within a specific 30 days. There are reasonable causes for missing appointments. Even the Medical Advisory Committee agreed that there should be exceptions for good cause, as there are in many areas of the statute that already give the insurers the tools they need to deal with doctor dodging. So, we have to look at why are we punishing the worker here? Who are the gatekeepers in getting into medical treatment and getting into light duty? Number one is the doctors. They do decide how often to see the workers. They schedule the appointment. And there's the insurers. The insurers have a ton of tools that they can use to get claimants back to work. And I'm going to list those. There's ORS 656-262 Section 4. Subsection D would be, if practitioners cannot verify the worker's inability to work, insurers can stop timeline. Subsection E, there can be a suspension if the worker misses a rescheduled appointment after already missing another appointment. Subsection F, Insurers can withhold medical payments to the doctors until they provide information on the inability to work. There's also 6562681C, that's the bug letter we've talked about. If you haven't been in treatment for over 30 days, insurer can send you a bug letter saying, get to treatment within 14 days or tell us that you're better. That is a huge incentive, a huge kick to the worker to get re-engaged. Perfectly acceptable option, and if the worker doesn't, the insurer can close the claim. There's also 656.325, which provides that if the worker is engaged in insanitary processes that are delaying their treatment, their benefits can be suspended. And most importantly is the bona fide job offer. There is nothing preventing an employer at any point from creating a bona fide modified job, having the doctor approve it. It could be sitting watching training videos. It does not have to be something physical. Basically, any worker could do a job that any employer could create for them. And then they get that approved by the doctor, they offer it to the worker, and the worker has some severe penalties if they don't accept it. So these are all tools that the insurance company already has, existing tools to help workers engage with their treatment. The gatekeepers, the doctor, and the insurers. Instead, what we're doing here with this, what we would be doing with this legislation would be punishing the workers rather than incentivizing them to get into treatment. Management's concept seems to think that that workers are not going to their doctors, and this is the reason they're not being released or returned to light duty. There's a lot of other factors that go into this. For some reason, there's this thought that all workers are somehow savvy enough to game the system and dodge their doctors to extend their time off of work. There's been no showing of this, and in my experience, it is completely the opposite. Every week, even this morning, I get calls, handfuls of clients a week, who call me in distress because they can't see their doctors. They're calling for appointments. They want to see their doctors. Doctor can't get them on the schedule. Doctor can't talk to them. This happens all the time. And so to put the pressure on the workers to do this when they're not the gatekeepers is fundamentally unfair. It doesn't mean that the worker is not engaged with their treatment. You know, I have, and when I'm talking about light duty, you know, so many of my workers tell me, my employer told me I couldn't come back unless I'm 100%. My employer was giving me light duty while I was accepted, but now I have this new denial, partial denial. Now they say, well, we don't provide it to denied client. I've had employers say, you can't go to physical therapy. We're too busy. You need to schedule all your appointments at the end of the month. There's lots of things that stand in the way of workers getting back to light duty and getting into treatment. And this, you know, demand that workers, come hell or high water, find a way to see their doctor every 30 days is not the solution to this problem. I'll also point out that workers are not paid time loss benefits when they miss appointment, when they miss work for appointment. If someone's on modified duty and they have to leave work to go to an appointment, that work, they have to use their sick time if they have any left, or it's an unpaid absence. You don't know how many of my workers, especially people in the construction industry or people who go out and work at job sites, their employers tell them, if you have an appointment, don't bother coming in at all that day, because by the time you get back, I don't know where we'll be, you can't come back. Now those workers missed a whole day of wages because they had to get to that medical appointment that no one is paying for. These are all serious problems that we need to talk about when we talk about worker engagement. And all these problems are not because of workers dodging their doctors. I had a current worker just recently. He had surgery, you know, for an accepted condition. Post-surgery, his doctor was on vacation. Didn't write him the work note, didn't write him post-surgical medication. Client had his finger cut open, it had no post-surgical medication. Office just says, sorry, doctor's out of town. You know, and I was able to beg the insurance company to pay him temporary disability during that time, but I had to beg them to do that. And that's an injured worker who would not have been able to pay his rent because his doctor was out of town. These are the kind of results that will be extrapolated if we put this hard deadline on it. There's also the question of rescinded notices of closure. I had a client who, her claim was closed, it got reopened, so she needed to re-engage with the doctor. This was in April. I called the doctor's office for her because she's a Spanish speaker, she can't communicate directly. And the doctor said June, 2 months later, was the earliest appointment they had available on an accepted claim. It's interesting that this was a doctor who was on the MAC board who said that 30 days should be enough. He couldn't see my client on an accepted open claim for more than 60 days. These sorts of things happen all the time. I'll also point out that, you know, the Mco enrollment, workers enrolled in the MCO, they have 14 days. to switch doctors. The WCD and their modernization project and bar committees are talking about this deadline, saying it's too short. Because I had a client recently was engaged in the MCO. We called the MCO and asked them to schedule the appointment. 2 months. It took 2 months. When I have an injured worker who's not getting treatment, not getting released to work, and not moving forward in his claim, not getting paid because the doctors couldn't see him. Again, nothing to do with his engagement. He spent hours and hours calling doctors. I also point out there was some discussion about technology in our subcommittee groups about how, we could just do a telemedicine appointment. Again, those all have to be scheduled, and that is a real problem for workers who do not have access to technology or do not speak English as their primary language. About half of my clients are Spanish speaking, and I can tell you most of them don't have email addresses. Most of them could not do a Zoom call. Most of them cannot call their doctor directly to schedule an appointment. They rely on interpreters or family or help. So this sort of rule would disproportionately affect people who do not speak English and people who have lower means, maybe don't have internet, computers, or access in those ways. So when we had the discussions around House Bill 4138, we certainly agreed to continue to discuss workers' engagement with care. And that's what we're doing. We think that it is important. In our minds, engagement and access are two sides of the same coin. You cannot have engagement without access. How is the worker supposed to have engaged with their attending physician if the attending physician is out of town when they need these work restrictions? If the attending physician takes a 2-month vacation, like happened in my case. If the employer is not allowing them to take time off, or they have to choose between paying their bills and being able to work or going to that medical appointment. What happens when the AP simply says, I don't need to see you back for 60 days, or after you finish physical therapy, or after the MRI? Those things should not fall on the worker on an accepted claim to lose their benefit. The insurers have not enunciated why this is such a large problem that it justifies changing the statute for everyone, including the vast majority of workers who are fully engaged with their treatment and go to all their scheduled appointments. They have not enunciated why their current battery of tools that they have, as I noted, are not sufficient to combat those few workers who might be engaged in some measure of doctor dodging. There's no data to back up that how many workers this is happening to, what that is costing the system versus what it would cost workers in general who are engaged, who are going to lose their benefits on day 30. This goes against all of the notice and opportunity to correct that we tried to do in House Bill 4138. I have, think of the worker who just had surgery for a compensable condition. Her doctor writes him off post-op. Do we really want that restriction expiring on day 30 if the doctor felt out of medical necessity that it was 45 days? We want workers to just somehow have to know that and doctors to know that restrictions expire on day 30 and scramble to fix it at the risk of not getting paid. It just makes no sense. Last thing we need is to give workers and doctors more paperwork, more instructions about how workers' comp is different than reality, and somehow assume that they're the ones that can process the claims in that way.
Joanna, I'm sorry, this is Sarah. I'm sorry. Can I interrupt for just 1 second? You keep talking about date 30, and I'm not sure where that's coming from, because this subcommittee was formed to look at the problems and look for discussions of how to come up with solutions. So, if day 30 was something that was done in the past, if we can keep an open mind here, and I hear the problems that have arisen, and I appreciate hearing them, but let's work together to come up with a solution, because I'm not sure day 30 and what that is really applies to this brand new subcommittee forms.
Yeah. Well, thank you, Ms. Upwell. I do appreciate that. And our prior discussions, that was the proposal from the insurance side, was that all restrictions expire at 30 days. And that's a proposal that they did discuss with MAC. So that's why I was okay. Focusing on that. I'll also mention, the idea, but thank you. I will talk more broadly, and I'm almost finished with that. But
yeah, no, I appreciate that. And I hearing what the problems are, that's a great place to start. So thank you for that.
Yeah, thank you. And I'll just mention on open-ended work releases, it's not usually open-ended till the end of time. Just because it doesn't say 30 days, 45 days, a specific date generally open-ended is tied to something, like the next appointment, or after you finish physical therapy, or after an MRI. So there's a really valid reason to have that, and that doesn't mean that the worker's not engaging. If the worker's finishing physical therapy and then the doctor wants to see them back, that is engagement. And so it's our position that if worker engagement is a problem of such magnitude that legislation is warranted to prevent this supposed doctor dodging, the solution should not be so broad as it will affect workers who are already following their doctor's orders regarding their appointments, even if those appointments are scheduled out greater than 30, 45 days. It's our position that insurers already have at their disposal a battery of tools to encourage and then force workers to engage in their treatment, and that those tools are sufficient. We haven't heard about why those tools are insufficient. What we do know is that workers have difficulty getting into medical treatment for a variety of reasons, and all of the pressure should not be on the worker to get into that treatment given all of the issues that arise. Thank you. I'm happy to answer any questions.
You're on mute, Teresa.
Recording stopped.
Sorry, that's what happens when I juggle too many things at once.
Recording in progress.
Okay. Sorry about that. There was a little glitch on my end, so I had to focus on that. I'll open up questions to MLAC members before I open up the conversation to those in the speaking queue.
I guess I would ask clarification. If that 30 days, because I do remember that the previous conversations around the open-ended time loss, if that is still something that is being proposed, or are we starting just from a blank slate? I'm confused on that.
Matt, just, another subcommittee member, I personally would like to start from a blank slate and understand what the problem is and see if we can come up with a solution together.
Thank you. I concur with that.
Great, thank you.
Any other questions for Giovanna? And Elaine as well. Should clarify that. Okay. All right, so going to speaking queue, Keith had his hand raised first, and then Kirsten is followed. So, Kevin Anderson, are you there?
Yes, sorry, I thought you said Keith.
That's all right.
If it would be helpful, I do have a case that I could kind of walk through as a hypothetical for why the current rules I don't think are adequate to address all these problems. I will try and keep it as a hypothetical, but the other attorney who was involved in the case is Keith, so he can fill in any clarifying information for me if needed. But this was an accepted case. The worker saw his attending in June. The doctor said, you need surgery, but you need to quit smoking and you need to lose 25 pounds before we can proceed with the surgery. So come back when that happens. He wrote a light duty work release. I believe it had an end date, so it was like 90 days out. 90 days come and go, and the worker is back at light duty. We don't have any concerns about him doctor shopping or, trying to game the system or anything, but he was instructed not to return until he lost a significant amount of weight and quit smoking, not easy tasks. And I came onto the case in the following March, so about 9 months later. No treatment had been done in the meantime. The worker was still on light duty with the employer, but we were in litigation because of one of the checks going out. And to explain why the current rules don't really address this situation, as we refer to them, the bug letter that says you haven't treated in 30 days or will close your claim. This case, the doctor provided an excuse for why the worker doesn't need to come back in 30 days. It was, I don't need to see you until these two conditions have been met. So I can't send him a letter and say, it's been 9 months, tell us what's going on with your treatment or we're going to close your claim. I could reach out to the worker's attorney and ask him those questions, but I can't force anything to happen on the claim. There is a end date to the time loss authorization, so this isn't a true open-ended one. But as I said, the employer didn't have any questions about this worker being on light duty. They had just kind of got lost in the system, and so we couldn't send the letters to the doctor saying, can you verify the need for the work release or the objective basis for it or anything like that. So the current tools we had basically left this worker in limbo. The claim was open. We didn't have any options really to close it. In similar cases, I might have called the doctor and said, hey, this guy hasn't been back in 90 days. Do you think you declare him stationary, or do you want to schedule another appointment, or what's going on? But we were able to work out a different resolution on this case. But that is one of the examples for why the current options that are out there of writing to the attending or sending notices to the worker just might not be enough. And if there were stronger rules about getting the worker back in to seeing the attending on a regular basis, that's something that might not have to get referred out to litigation. So I'm happy to answer any questions anyone has, and I'm sure I'll probably chime in throughout the rest of the meeting today and future meetings. So.
You're muted again, Teresa.
Sorry, thanks, Matt. Thanks for, it takes a village. So Keith, is your hand raised to respond to Kevin, or?
Yes, it is.
Okay, just my thought.
The facts are broadly what he suggested, but I think what's missing here is the fact that really nothing was done by the prior attorney. Kevin came on the case very late, as he noted, and really nothing was done by the employer or the third-party claim processor or the prior attorney to disrupt the status quo while my client was trying to lose the weight and quit smoking. So in a lot of cases, you would see some communication where there had been a phone conference with the doctor about kind of how long are we going to wait for this? Is there progress being made? Is he continuing to do the unsanitary things that are causing the ongoing problem for him? There were a lot of tools that could have been used to process the claim, and that is the legal obligation of the insurer and the employer, not the claimant. He continued doing the job that his employer had agreed to offer him. He followed the instructions of his doctor, and nobody said otherwise. There wasn't a place for him to tell the doctor, no, I want to see you every month while I'm trying to lose weight and quit smoking, and get this to the place where I can have surgery. And there was also problems with getting surgery scheduled because of COVID. There was also concerns about that at some points along the way. But I think the bottom line is that there were a lot of things that could have been done that weren't done to close the claim or drive the worker back to the doctor. My client would have been more than willing to see his doctor more frequently during that time if someone expressed a problem with what was going on and following the doctor's advice. So that's just kind of a basic synopsis of everything that went down on that claim. Thanks.
I think Kristen is up next.
Yes, thank you. I'm having problems with my microphone at the moment.
If there's anything else, I was going to kind of respond to a little bit of Giovanna. So if there's anything else having to do with Kevin and Keith's claim, I don't know if you want to wrap that up or if there's anything else on that.
Kevin, did you want to respond back to Keith on that one?
Sure. The one tool that might have been an option was this injurious practice notice, where we send a notice to the worker saying you're doing something that's harming your recovery, please stop, or we'll suspend your benefits. I don't think it's a reasonable option on that case to force a worker to give up smoking. It's not an easy ask. In 10 years of practicing, I've only seen the division grant one of our requests for an injurious practice suspension notice. It's a very, very high burden for us to show what the worker is doing is harming themselves as opposed to just not improving themselves, if that distinction makes sense. So again, I don't think there were many options available for us, even if I had been involved earlier in the case, other than a phone call to Keith saying, you know, hey, what can we do here?
Okay, so with that, we'll turn back to Kirsten.
Sure. So first I wanted to echo what Elaine was saying, that this goes beyond just the insurers that are concerned about this, because as employers, you know, we want our employees who are injured to be getting the treatment they need and want them to be able to get back to their positions as soon as possible and as soon as is, you know, reasonable. So just wanted to echo that this is a broader issue than just for the insurers. And then also to Giovanna's point, I like the idea of us starting from kind of getting everything out on the table, because we are not intending to make a gotcha situation for the workers, and I don't think that's any of our intention here. I think we're looking for a way to make sure the system's working, and you know, we're aware that there are limitations and things that happen, and so I think getting all the concerns out on the table and having that discussion of how do we balance all this, how do we make sure that you know, employees are getting the work they need, but are getting the treatment they need, but also making sure that it's happening in the time frame it should be. So I like the idea of us kind of getting this all out on the table and then trying to work from there, because you know, we don't want to set up them for failure. That's not our intention here. So
Thanks, Kirsten. Scott?
Yeah, thanks. Mostly a question for I think Kevin, the previous commenter. So in my personal experience as a medically stationary worker, it's typically either the MCO, the provider, or the insurer where the hang-up is in terms of the treatment and the continuing access or continuation of care, either through red tape or miscommunication or an issue there. Can Kevin perhaps point out how an additional burden on the worker would have helped in that situation? Because again, it seemed like there was an issue between the insurer, maybe to some extent the employer, and then the provider. And I don't see how placing an additional hoop or hurdle or cutoff date on the worker would have helped that situation in any way.
Sure, but I don't view it as an additional burden on the worker. I see it as setting a clearer standard for the doctors about what they need to be doing. The instructions on this case to the worker were to do two things: lose weight and quit smoking. Two medical treatments, so to speak, but weren't really directly related to what the accepted condition was. And because there wasn't a clear requirement for them to follow up or do anything, the doctor just said, hey, you know, if you don't want to lose the weight, don't want to quit smoking, you can live through the condition without the surgery, you know, I don't need to see you. You know, that's kind of where it ended up. It wasn't like the doctor was having more frequent meetings with this worker to be like, okay, what happened in the last 30 days? Are you down, you know, a pack of cigarettes? Are you down 5 pounds? You know, what else can we do to help you get that weight reduction to quit smoking? The worker was just kind of left to their own device to figure out what they needed to do, and just said follow up as needed. But if there's a clear rule out there, whatever it is, you know, 30 days, 60 days, you know, not open-ended, but with a clear end date and return date, then the doctor at least knows, you know, I'm not losing communication with this worker indefinitely. I will see them again in a month or 2 months or 3 months to try and figure out what's happened, what needs to happen. Should there be some sort of communication from the provider out to the insured or the employer about what's going on? It was a case where everybody was kind of okay with the status quo. The claim was open. He was on modified light duty, time loss, but he wasn't receiving any medical treatment. He wasn't making any progress towards medically stationary status. That would be my view on it. You know, if there's a clearer rule, I think it actually helps the providers understand what their role is, without it necessarily being the worker's burden to tell them, hey, this is what you should be doing.
Right, I think my question was that the issue that would then result of not having an additional follow-up would be the worker would be out the time loss, potentially, I think is kind of what's being discussed. So again, I'm not really seeing how penalizing the worker for an issue between the insurer and the provider would help in that situation. But I thank you very much for that, and maybe that'll become clear as we continue to discuss.
Sure.
Okay, so next in the queue is Jennifer Flood.
Actually, I think Jess was first.
Okay, sorry, Jess.
Okay. I guess, Kevin, since I know Co-Chair Dr. Wall, you asked us not to talk about a hard deadline, but 30 and 60 just keeps getting thrown out there, and I'm trying, labor wasn't part of the OTLA safe conversation that led us here, so I'm just trying to wrap my head around it. So Kevin, you talked about so if there was a hard stop, you envision the way that this rule plays out as the worker being able to tell the doctor, look, I'm going to lose my 2/3 wage replacement and job protection associated with comp unless you see me within 60 days.
I wasn't trying
whatever the hard stop is.
I wasn't trying to suggest that 30 days or 60 days should be the hard stop or
Yeah, we can throw out any days. I'm just trying to understand how, from your perspective,
My point is that if the doctors who are handling these cases know they need to see a worker every 30 days, they need to write a work release every 30 days, it's less of a surprise to them when they get the urgent phone call on day 29 saying, like, hey, I have to get in. It's when we talked to the medical advisory committee, they were kind of on the mindset that 30 days was the rule. I don't know that a hard deadline is exactly where we need to start off the discussion right now. I also don't know if that is the solution to keep in my case. My point is that the rules that we have right now weren't adequate in that case to get that worker any treatment, to move the claim to closure, to provide any clarification to anybody that was involved. It only got resolved because I got involved with the case and picked up the phone and called Keith. Not the providers, not the insurers, not the employers. It took 2 attorneys to resolve this issue, and that shouldn't be the case in our work comp system. It shouldn't fall on the attorneys to try and wrap up all of these things. It should be something that the providers know what's expected of them, that the workers know what's expected of them as well. So I would say what we're looking for is clarity in that and kind of to strengthen that rule for the worker to engage in the treatment and keep following up, as opposed to just my claim's open and accepted and that's it.
Okay, that's helpful. I have a hard time believing that if there was a hard stop on it, the medical system is what it is right now. A worker is going to be able to get in the next day with a comp provider. And, we've had conversations about opening it up to PAs, and I think there are further conversations about opening up providers to NPs because there is not enough medical providers that do workers' comp care. And I do think, to Scott's point, that if there is a deadline, I don't care what time it is, until there are more providers that are willing to do this type of medical care, losing 2/3 of your wage and your workers' comp protection is the outcome when the medical community can't meet that need. There already aren't enough providers. And we have an affiliate who couldn't be here today, but I do just want to raise another issue that has come up that is in this realm. And that's folks not having full wage replacement when they need to seek medical care. If you're a worker who is exhausted your 40 hours of paid sick leave, and this happens often, and then you're working part-time back, but you need to go to physical therapy or whatever it is, and you can't afford 2/3 of your wage replacement for that 6 hours that you needed to be out that day, you can't access the care. It's just financially impossible for you to do that. So that is another issue that I would encourage you all to look at. It's not just that workers don't want to go to the doctor. It's sometimes that they cannot afford it, because if you're a minimum wage worker, 2/3 of your average wage is not enough. So I would just encourage you all to think about it from that lens as well.
Okay, I'm turning to Elaine and Keith. Are you in the queue to respond to this current conversation? Piece of the conversation?
I was in the queue because my name came up a couple more times, so
I figured.
I didn't want to keep going in and going deeper into this case, but I will mention that that really nothing was done at all in the insurer's options to change the trajectory of that claim. There wasn't a phone conference with the doctor that was recorded. There wasn't a letter even to the doctor asking for more frequent contact, help with smoking cessation, help with weight loss. There wasn't a request to change the bona fide job offer, except my client actually went in at some point and said, this is an adequate wage while I'm trying to get this done. I need more hours. So my client actually did engage to try and get back to more work. And otherwise, this is just a normal claim where the guy's trying to do what he's supposed to be doing. And, the insurer who either wants to get this guy back to more work or wants to get things moving along and get the surgery done or conclude that it's just not going to happen. There was no effort to change the trajectory. And a lot of this, almost all of it, happened before Kevin was involved. And it could be that Kevin would have seen this going on and on and on, and he would have made the phone conference happen. Or he would have sent a letter that could have been sent to the doctor saying, hey, what's going on with this worker? How long is this going to take? Is this going to go on for years and years? None of that was done, though. So, again, if my worker had been asked to see the doctor every 30 days, he would have done that. Maybe even if the doctor had been asked to see the worker every 30 days, maybe he would have done that. None of that happened, and it's really, not on the injured worker who's just trying to get by, lose the weight, get the surgery for a hernia surgery. It's not on them to tell the doctor what to do. It shouldn't be. And we've already talked about hassle factors with doctors not wanting to treat injured workers, and there's plenty of that going on. I would mention that this doctor wasn't a part of an MCO, and my client wasn't enrolled in an MCO. The MCO rules require the doctors to see the patient every 30 days, and that's fine. And the doctors can be penalized for not making that happen. The MCO can call the doctor, and the MCO can sanction the doctor. None of that was done, but those tools exist. But they're aimed and directed at counseling the doctor, not putting the sword over the injured worker's head. And that's what we have a problem with when it comes to the idea that we put a hard deadline on restrictions. And I'm going to keep talking about that because that is the thing that has been talked about from the very, very beginning of this discussion is a 30-day hard deadline. So I don't know how we suddenly divorce the conversation and kind of go back to square one when that's all I've heard about for God knows how many years, since 2019. So anyway, that's my piece on that case.
Okay, I'm turning it back to Kevin. Do you want to respond, or can I go into the other in the queue? Others in queue.
Just briefly, all I wanted to say is I didn't mean to rehash this case with Keith. He and I were able to work out a mutually beneficial resolution to all of this. So I appreciate his patience on going through this case. But it was just an example of where a worker gets lost in the system, and it didn't seem like the rules were helping him or helping us. So with that, I was kind of hoping to move past our one particular case.
Okay, with that, I will turn forward to Jennifer Flood.
Good afternoon. I'll take this down now so I don't forget later. I just wanted to chime in and share that from our office, the examples that Giovanna and Keith and Kevin, all of those examples are things that do hit our office. But to reiterate what they've already said and not drill on about it, is that to have, our system has a lot of complexities in it, and access to medical treatment is difficult. I know you can say, oh, there's doctors all over the place. It's a very, very common everyday call that we get where a doctor or a worker cannot get into a provider, or a provider won't take the workers' comp claim because it's more than 30 days old. That's another 30-day example there. But I don't feel that the fix to the issues that we're talking about should fall on the worker's back. Because the fix is cut off the time loss. Like, that's going to cure it. It's not going to fix the issue. And workers, especially non-English speaking or folks that are intimidated by medical service providers or their staff, you know, they get angry about, hey, I can't get in and I've got to get in. Well, next thing they're told is they're no longer welcome there. Some of that is brought on, I understand, from some of the attitude, but many times it's, you know, well, if you're on that type of a time frame, we can't accept you as a patient. So I just wanted to share that workers not being able to get into the doctor, having the benefits cut off be the fix to this, and as Jess pointed out, many workers aren't paid to go to the doctor, or, as I have found out, because in my world, I can take 2 hours off and still work the rest of the day. But in many job environments, they can't. If they can't be there for the full shift, they're not welcome to come in at all. And they end up losing wages for that entire day. So I'll leave it at that, but I'm here if you have any questions.
Okay, next in the queue is Carl.
Good afternoon, everybody, and welcome back from summer, right? And here we are, right back where we started. Everybody's made really good points. I'm, for fear of repeating myself, I'll just say working conditions. And the fire service is a huge example of return to work or light duty or whatever you might call that. And one of the things that we are able to do in a collective bargaining environment is actually bargain that time loss or lack of time loss to go to our doctors or physical therapy appointments, but that's not the norm. So when you go and receive a treatment care and it involves a light duty assignment or alternate duty assignment, if we are going to work towards some hard date, which I'm not a fan of, is that we have to provide balance. This is the workers' compensation program, not the employer's compensation program or the insurance compensation program. The worker here is already under extremis if they're at 2/3 of wage earning, or if they're at light duty, potentially they're using other leaves to make themselves whole. So Jennifer made a good point about partial shifts and all those struggles. I think any discussion about these things, Sarah, to your point of bringing up other items, would be this lost time for doing what a physician ordered you to do on alternate duty. And I'll let my other colleagues stand on their comments. But I think it's a very important piece moving forward, and thanks for the opportunity to talk.
Okay, Elaine.
Yes, hi, Elaine Schooler, Safe Corporation. I'm actually, if you don't mind, going to wait and let Dave Berenberg speak first.
Sure.
Thank you.
Hi. I just wanted to say I'm really frustrated with this conversation for a couple of reasons. SAFE and I think the business community agreed on 4138 in good faith to have a discussion on worker connection to the care in the interim. And we said that we would do it without preconditions and without a predetermined outcome. And we were hoping to start with, our saying what we see as the problems, and if folks had questions and want more information, we're happy to provide it. We're happy to then, our thought was, folks could start saying, oh, there is, a problem, which I think was said on the record that there was an agreement, that there was issues that we wanted to work towards looking at and addressing. And then trying to talk about them. And there, rather than just trying to shoot down an idea that we had taken off the table so we could have a discussion starting with our concerns. some of the things that we've been talking about today are, it only affects a few workers. Well, a lot of the changes we've agreed to in the past in legislation affect only a few workers or a limited number of workers. But, we're happy to look at and talk about why the existing tools that, the trial attorneys say exist, and do exist, but why they don't work in a real practical way. We're happy to look at things like, are there things we need to do that can make it easier or less strain for workers to attend appointments, and other things that are being raised. We're not trying to railroad a specific solution. And, if it's the hours that are missed and they're not effectively compensated and impacting workers, put that on the table and let's discuss it, rather than just say in a really dismissive tone, we can't talk about this unless we talk about the other thing. We're willing to talk about the other thing. So, I just think we need to de-escalate a little bit and get back to, how do we address the issues where there are problems of workers being connected to care. We take it all on, the access is an issue, is a problem. We don't want to penalize workers for that. But it's just not a constructive tone, and some of that might be on us. But that's not the way we wanted to approach this. So, I'm hoping we can just tone down the rhetoric and, move forward in a really collaborative way as we, often are able to do. So that's it. And thanks for hearing my harangue.
Thanks, Derek. Elaine, did you want to chime in before I turn the floor to Keith?
Yeah, I just wanted to go back to some of the other tools that were raised as ways to manage claims when workers are not actively engaging with their medical provider. I see a lot of these tools as either overly punitive, counterproductive, or in some cases taking a sledgehammer to something that may not really require such a broad stroke, but maybe a more refined solution. For cutting off time loss payment when workers fail to appear for medical exams, that only works when the worker has a scheduled follow-up appointment. So for those workers who receive an authorization, leave the office, do not schedule that follow-up appointment, that tool is no longer available, is not available at all to the insurer because no follow-up appointment has been made, so there's no follow-up appointment for the worker to miss. Also, withholding time loss benefits if the provider can no longer verify the worker's inability to work. Practically, many of the medical providers don't, are unwilling to change work restrictions until they're able to have contact with the worker, with their patient, to verify how they're doing. And so while we can use that more often, it's the case that the provider will stay with the restrictions until the worker is seen or there is contact being made. And another tool is cutting off payments to providers who are not reporting on the worker's ability to return to work. Quite frankly, that seems counterproductive and against the goals of bringing providers into the system, more likely to drive providers out of the system. If that type of practice were to be taken up by insurers, we want providers to remain in the system. We want them to be engaged in their care with their workers. What we're looking for is what we think would be a clear standard for workers and for providers to maintain that care so that it's clear to all, to the two primary participants, I guess, in the system. And then closure of the claim when the worker hasn't treated the bug letter. Those are difficult to do at times. Workers can respond that they've scheduled their appointment and then miss that appointment, and the process starts over. It's a high burden to prove, in my experience, with strict requirements. And then ultimately, the biggest problem is that it results in closure of a claim where a worker is not medically stationary. They haven't recovered, in most cases, from their injury, and now we're going to close the claim. That's not the goal of the system. The goal of the system is to help those workers recover, ensure that their recovery is tracking in an appropriate way, and closing the claim administratively really doesn't achieve that purpose. And it also results in a shift in the medical services that are available to those workers. It also ends their time loss payments completely. The only way that they can restart those benefits are by having the claim reopened or by having that closure reversed. Those are all pretty harsh tools when what we're seeing is an issue of continued care, continued access that could have some more tailored solutions. As David mentioned, the payment piece for workers missing time at work, yes, the statute allows workers to receive time loss benefits for 4 hours or more of missed time from work doing medical appointments. If that's a concern, this is a forum to discuss that piece as well. I think in the past we did propose a time limitation, and that would still be a proposal of ours. However, we are open to other solutions to tackle this problem because it's an important one. And I'm happy to answer some more questions. Actually, I did have one or two more pieces. There was a comment that it would be too cumbersome for doctors to address work restrictions. There were no comments from the Medical Advisory Committee, to my knowledge, about that being overly cumbersome. Falls directly within the doctor's standard of care to address work restrictions when they're treating injured workers. And that would be true of any doctor treating somebody who was injured and was unable to work. They would be expected to address the work restriction. So I don't see this being overly cumbersome for them. And then the MCOs have presented in the past to MLAC about timelines and worker enrollment and access to providers. They may be an additional resource who can provide further information to the subcommittee about those treatment time periods and workers' ability to access providers on a regular basis. Now I have mentioned everything. Thank you.
Okay, thanks. Keith?
Yeah, I really don't mean to keep beating a dead horse, but it keeps coming back up about the hard deadline and the proposed solutions. I was looking back through my email to try and figure out where I got the idea that that's where we were starting, and I've got one from June 18th saying, from SAFE's perspective, that's where we were starting, that they were going to bring back the same proposals they had brought before, and that's what would be before this subcommittee, because that's what they were going to request. So, I mean, I guess I apologize on behalf of our group if we totally misconstrued what we were going to be doing here, but we've been given every indication that we're talking about, the proposal being the 30-day hard deadline on work restrictions. And I'm sorry if that really, really offends us to turn this around and say that workers have to force their doctors to provide care instead of the insurer either making a phone call or sending a letter or doing one of the multitude of other things at their disposal. Instead, every 30 days, the worker and their family have to scramble and figure out whether the work restrictions are adequate and what else they need to do to force the doctor to get the restrictions done. We keep hearing about the Medical Advisory Committee, and that's great. Many of those doctors are MCO providers, and they've always been subject to 30-day deadlines for seeing injured workers. Yet you heard from Giovanna that one of the people on the MAC wasn't available for a couple of months to give the work restrictions. And that worker would have been swept up in this idea of some sort of hard deadline. So I guess if we're not talking about a hard deadline, I'll let that go. But like I said, I mean, that's what we've understood from the beginning, and that's why we've responded the way we have, because we see that as just a drastic step to deal with a relatively small problem of doctor dodging. I mean, that's really what we're talking about here. We're talking about workers who are deliberately not engaging. Otherwise, why are we putting it on the worker to force the doctor to see them if they are following the doctor's orders? If there's a problem, we need to know the scope of the problem, and we need to find a proportional solution. And what we've heard so far isn't that. So I guess we'll take it from there.
Since Kate has been very patient and waiting for us, I wanted to turn the floor to her before going back to this line of conversation.
I'm happy to wait, Teresa. My comments
Okay.
are all.
I just wanted to check to be sure. Thank you.
You're muted, Teresa.
Sorry. So Dave, I'm presuming your hand is up to, in response to Keith, or is it?
Yeah, I just wanted to say, then let's just start from here. SAFE's position is, we see that there's a problem, we're open to a discussion of solutions. We've heard lots of problems articulated by workers, representatives, or ombudsperson. We're happy to have discussions of those and trying to see how we can, move forward and address them. And just again, want to take the tone and piece down. We understand that there are problems with workers accessing care. We understand that there are issues for primarily non-English speaking workers and low-power workers who have lack power in relations with their employers. And we're willing to talk about all of those issues too. And so, we're happy to start fresh. And our representations, at least lobbyist to lobbyist, in the discussions was we would start this discussion without preconceived notions. And that's where we are. And so please let's start with that sense. And, a question, we're happy if the chairs want to ask questions of all parties or how they want to structure it is, if you think that there aren't the appropriate tools, respond to the trial attorneys in writing, to the committee about how we see those not working and the practical solution. How is it, I guess my question is back to the chairs of, you've heard a lot of discussion and disagreement. What would be helpful to you in information or presentations moving forward to help circle around something that's a productive discussion rather than just the sort of pitched battle that we seem to be having today?
This is Matt. I do have one question. The MCOs came up, and then the MAC keeps coming up, and so I'm a registered nurse. And I will say that some of my perception of the discussions around the MAC is that there's some distortions in the expectations of how physicians operate in the world. And that they actually, I think it was mentioned, all the physicians thought there was a 30-day limit or whatever. My experience with physicians is they tend to think they know the rules, and then they may agree to rules, and then on a shift or in an occurrence, they will then try to say, does that rule really exist? Does it apply to me? They don't necessarily, in my experiences, track all of policies and rules that are maybe outside of this practice of medicine. And so I think it would be really great to have dialogue. I would love to engage in some dialogue with the physicians on the MAC about some of their perceptions about how this works, and that would be helpful. And then back to the MCO, and I believe MCOs rely a lot on RN care managers, and so I'm wondering, is that outside of the is that a practice that's occurring outside of the MCOs in other venues in the work comp world? Because what I think the evidence shows is when patients are engaged with RN care managers, the complexities of the healthcare system get a little bit more ironed out, and we see access to care improve or compliance. And then that's also what I think this comes down to, is compliance. And so the evidence also shows that punitive measures do not increase compliance with patients. And that is like long-standing. I mean, this is I did a literature review the other night around just compliance issues, because that's what I believe this is, or what this is being framed as. And going back into the early 1990s, there's some pretty, good articles in the medical journals around how do you get folks to comply with their medical treatment plans, which is a chronic issue in healthcare, right? with people who have chronic diseases or what have you. Making it to appointments appropriately is a big issue, following medication treatment plans. And so when you see like what actually gets patients to comply so that we can lower costs in the healthcare system, incentivizing is typically the way that happens. So the studies where you actually pay the patient to make their appointments, and then they make their appointments, and there might be better outcomes. So I guess one thing I do need clarification of is, are we looking at punitive measures for the worker? Because, like, based on the evidence, punitive measures do not work. And I think the example that came up about the patient who needed surgery and had to lose weight to get there and quit smoking, those are two disease processes that, again, physicians are some of the worst at stigmatizing things like smoking and losing weight. And so this physician says, hey, you need surgery, you're not going to get it until you lose weight and quit smoking, and that's on you, and the evidence shows that that's not a very effective approach. Incentivizing, on the other hand, may be more effective. So I guess what I'm hearing from some sides is like we're looking to move into a more punitive measure for workers, and then that may lead to compliance. And then I'm hearing, well, that isn't necessarily true. So I guess I have questions around that. Are you looking at a punitive measure, something that would decrease or lose benefits, and the belief being that that is a tool that will increase worker compliance with staying engaged with their practitioners? And so that would be one question. And then the other is, I think the evidence just shows, are we open to like incentivizing this process in another way, which would be in the scope of the division here.
So Elaine, your hand is raised, I'm presuming, in response to the conversation?
Yeah, I mean, I just had a few thoughts. I don't think it's punitive or incentivizing. I guess I see it as somewhere in the middle of the two. I think it can be cast as one or the other, depending on your perspective. But I think the goal is for workers, how do we have workers remain in contact with their provider when they're off work receiving time loss benefits? That's the problem, right? And we had a solution that we brought forward to the trial lawyers, and maybe there are other solutions and better solutions out there. That's what we're here to discuss. But the problem is for the worker who's recovering at home and they don't have that regular contact with their provider. That's when problems can arise, when you don't know how the recovery is going. Are they having complications? Are they having adverse reactions? Or are they doing great? If that's the case, the provider should know that too, because changes in care and expectations then can happen when there's that contact between the provider. We're not trying to make this a gotcha situation. We're just trying to ensure workers are remaining connected with their medical provider, so that there aren't those gaps in care.
When you say provider, you mean the attending provider? Okay.
Right.
And within these, and so I'm still trying to navigate all of the statutes around work conflicts is exhausted. But so my understanding is the attending is the only one who can. It's rather archaic, right? The attending is the only one who can sign off on that, and they have to be like either an ND or a DO. Is that accurate? Or can they be an APRN as well? Advanced Practice Registered Nurse?
I don't know about the APRN designation. Nurse practitioners can serve as attending physicians, and I believe in the MCOs they do in some cases too. There are some providers who are limited, like chiropractors can only serve as the attending physician for 60 days or 18 visits. And there are some other limitations statutorily, but the attending physician is the one who authorizes the time loss benefits and monitors those work restrictions to ensure that they remain appropriate throughout the worker's care. And I also wanted to bring up too, one of the pieces we had talked about, and this goes to Giovanna's piece is that for those workers where there is like a doctor on vacation or a gap that happens, part of our goal with House Bill 4138 was to fill those gaps by increasing the retroactive authorization period from 14 to 45 days, which is a substantial amount of time for a doctor to go back in time and authorize additional time lost benefits. So, there are more solutions, I guess, coming down the pipeline in the future that will aid workers in those situations, and I think could complement what other solutions could be to this problem of ensuring regular contact between the worker and the provider.
So I have an anecdote. I talked to an ONA member, so a nurse who got injured. And nurses are savvy with the healthcare system, so there's a lot of benefit to that. And it's been a year and a lot of struggles, but this individual sees an orthopedist for the injury, but their attending is not. Their attending is just a general practitioner. And they've kind of been going through the process of first they tried physical therapy, it was ineffective, and then they went for a minimally invasive procedure, and that was ineffective. And then it decided they had to have a more invasive surgery, and that was booked out like 60 days from that determination. In the time since that minimally invasive surgery and having to, and I'm getting scheduled to have this more invasive one, the attending provider, there isn't a lot of value. Like the worker nurse is going and doing light duty, so it's like this burden on our already burdened healthcare system for this individual to have to go see their attending in this time frame when between like getting the surgery scheduled and when the surgery happens. If we were to pick like an arbitrary number, because of just how scheduling goes, they're off quite a while, and the attending isn't going to have much to change their light duty restrictions or anything like that, or anything really, because the patient's condition hasn't changed. So I guess that's where I wonder if there's opportunity, or if you all feel there's opportunity in looking at what I believe is a rather archaic method of saying that this attending provider is the only one that can, if there's a rationale why that would be, and why only this attending is the one who can do this, and if they're seeing other specialists. And now like physical therapists are required to have oftentimes doctorate degrees, so why are we putting the burden on probably an already overwhelmed physician's office to basically check a box when the patient is engaged in their care? But if we're worried about, because this idea that like by seeing a general practitioner in a 6-month continuum of treatment is somehow going to make the patient better, in my opinion, is false. So is that where there's opportunity, is maybe looking at allowing other practitioners the ability to answer some of the questions that you all would have about where the worker is?
Sure, yeah, I mean, that could be a possible solution. I think the challenge is that with the attending physician, when you start looking at multiple providers treating a worker simultaneously, it becomes very difficult to determine which restrictions are the controlling one for, let's say, a worker who has a modified work release but has 2 different releases from 2 different providers. How does the employer then accommodate that and determine which is the appropriate restriction in order to bring that worker back to work? And with the notice requirements that were part of House Bill 4138, where insurers are required to provide notice to workers when their time loss benefits are going to end, where we have overlapping attending physician authorizations, that could become very problematic because we don't know which time period or authorization to honor as the valid one, and that would result in more litigation. Conversely, if there were more providers who could address the work restrictions, broadening the healthcare access piece, that could alleviate what you see as an issue too. If workers have more access to care, and not necessarily having the overlapping restrictions, but a broader pool. And maybe others have thoughts on how to get that information, if that's something that the co-chairs would feel would be useful for this discussion.
Thank you.
Okay. Giovanna, do you have anything in response? I'm presuming you have your hand raised in response to the conversation.
Yes, thank you. So I just wanted to touch on Mr. Calzia's point that, we're talking about engagement with treatment, but that doesn't necessarily mean seeing that one person who's been designated as your attending physician. Not seeing your attending physician for 30 days or 60 days or whatever hard deadline might eventually be offered does not mean there's no care, right? Oftentimes people are treating with the surgeon, who usually will not be the attending physician, but is in communication with the attending. If they're going through a physical therapy program, if they're waiting for diagnostics. Another big one is work hardening. A lot of folks go to a work hardening program where they, near the end of their claim, so that they can get ready to go back to work. If the work hardening program is 8 weeks and the worker has to complete it, the AP might decide not to see them during that time. That doesn't mean the worker's not engaged, just the worker's going in every single day. So I think that needs to be broadened too when we talk about engagement. It's not just with the attending physician. And finally, what I wanted to point out was, I heard Elaine say something great that I think we can all agree on, and is a really good starting point for these discussions when she was talking about the withholding TD if it can't be verified, and why that statute doesn't provide enough for them. Providers are generally unwilling to change work restrictions until they are able to see the worker. I completely agree with that statement. Workers have this problem. They can't get their providers to talk to them or change restrictions between appointments. Apparently insurers have this problem too. The question is, if we all agree that this is a fact and this is a problem coming from the providers, let's not draft a solution that penalizes the worker on an accepted claim who has these benefits so that they can get better and go back to work. Let's not penalize them for something that is the providers doing. So I just like to keep that in mind going forward on discussions. Thank you.
Thanks, Giovanna. Kate, thank you so much for your patience and waiting. The floor is yours.
No problem, Teresa. And sorry if my sound is bad. I'm having an issue today. I'm Kate Sussman. I'm one of the attorneys at the Northwest Workers Justice Project, and we represent workers in low-wage jobs and employment matters. And many of them have been injured at work. So one reason I try to come to these meetings when I can is because the lens that I have through the eyes of the workers who are navigating the system, often on their own, sometimes with attorneys, and there's some amazing attorneys who speak Spanish out there, but they're not enough, and often they're navigating it on their own. The lens we bring is, how do we reduce barriers to use this system, to access it, and have it be successful and get back to work, which is very rarely the result, I'll say, of our clients' experience. But we see people have a hard time finding care. We have a lot of clients in rural areas too. Finding Spanish-speaking care is very, very hard. The quality of care is often, the workers often feel like they're not being understood, they're not being respected, heard, that they really don't feel like the system's working for them. And they also have lives to live. Like, if I had a workers' comp injury, I could sort of integrate it. I have flexibility, I have power in my job, but my clients don't, and their lives are complicated. And I don't even understand the proposal today, I'll be totally frank, and I was a bit late. But it just sounds like it's adding barriers instead of thinking about reducing them, because this is a one-size-fits-all system, and I'm not going to have the same experience as some of my immigrant clients who just don't have all the language resources, the flexibility in their jobs, and the things that I would bring. So anyway, that was just the kind of lens I was hoping that you can bring as you go forward with this complicated discussion, which I'm not tracking every angle of it and not totally sure, but it sounds like it's a more rigid, hard system, and I think that generally doesn't benefit workers. Thank you.
Thanks, Kate. And I'll let the Matt and Sarah chime in. So I hope this is not an editorial comment. This is the purpose of today's meeting is really just a kind of discussion of just general topics and kind of starting to scope, different people's perspectives. And then the following meeting, the focus right now is primarily on information follow-up requests. And we'll talk about that at the conclusion of the meeting. But I'll turn it over to Sarah and Matt too to add anything else that I'm missing.
No, that is correct. That is the intent of this meeting, is to look at some of the problems. I don't know where we're at. If there's more testimony that people want to provide, but I have been tracking some of the problems that I've heard. And I know that Matt and I already have asked for some follow-up, but through the discussions to date, we might have additional follow-up. And I don't know how long we want to save for that in the meeting. So my thought is if there's more testimony, we should go get through it in the next maybe 10 minutes. What do you think, Matt? And then spend some time on what we see as a problem and then come up with what we're looking for in the future.
That sounds good to me. Thank you.
Okay, I don't see anybody's hands raised at the moment, so I will one last round of or anybody participating that wants to chime in before we turn it to next steps. Okay, well, that was easy.
Teresa, do you want to kick off with, some of our thoughts initially with some next steps, and then
Yes.
Matt and I can add to them?
Yes, so the three of us met, Matt, Sarah, and I met yesterday to talk about kind of formulating a skeleton of what the subcommittee meeting would look like. So I have been asked to invite a number of individual entities to come and present. This would include representatives from MCOs, the ombuds for organ workers, ombuds for small business as well on that. It's my understanding from talking to WCD, we may not be able to get full MAC representation on the 16th, but we're working on ways of sharing information. Also, what came about from this meeting, I sensed since prior MAC meetings were mentioned quite a bit, it would probably be a good idea for me to gather some relevant information from prior MAC meetings related to the scope of the subcommittee to share with all of you there. Also, there's an information request for what other states are doing in regards to this, kind of as much as we can, an apples-to-apples comparison. So I've started the conversation with WCD about this. We will meet afterwards to talk about narrowing, the parameters of what our research will entail, and run it by Matt and Sarah to make sure we're on the right page to get it together. But our goal is to have that information available at the next subcommittee meeting.
And Teresa, the tentative date, right, is September 16th, but that is not confirmed, so it's penciled.
Yes, it is penciled in.
Okay.
And I may have missed one possible information request that should be presented at the 16th as well. That came about during the meeting. Scott's hand's raised. I know I missed at least one item. I promised more than one.
No, it's not that as much as, I know that they'll probably be, we've had some great discussion about this, and I think, I'm already kind of trying to bubble away with some ideas here. As we reach out to stakeholders or, snap awake at night and have an idea for some insight or some other information, what's the best way to kind of get that flagged for a future meeting?
That's a good question.
And while you think about that, I want to reiterate, I would be really interested in hearing from MCOs and maybe some providers and others. I think that's a great point, and I really appreciate that being already in the works.
Yeah, and we have some ideas on that. The other piece, actually, I know that I won't share it today. I have it available, but I'll wait till the next meeting. Is at a prior MLAC meeting, WCD put together a matrix of all of the different healthcare provider groups and their current statutory authority to being an attending physician. So it includes their authorization timelines and all of that. So that is already published. That will be part of the information we will share for the next meeting. But I can't put it in the chat now. That I do have it available, but I'm not sure if it's relevant for this piece of the conversation or would be more appropriate for next time.
Great, thank you.
So I don't know, Matt, if you're interested in hearing what I heard from the problem statements today, and then if you want to add to it and kind of go from there. What do you think? Okay. So what I heard, there's a couple things Giovanna laid out that the existing tools do work, and I've heard that the existing tools on some cases do not work. I know we addressed that verbally today, but I think something in writing to further solidify what's working, what's not working would be helpful. I don't know how you feel about that, Matt. I don't know if I fully tracked or understood how they're working and why they're not working. Would that be helpful to you too?
Yeah, I would appreciate that, just because I hear the statute number is riddled off. I'm not an attorney, so I don't have them memorized like some folks. So I think something in writing that could help me kind of dig into that would be helpful.
And then I also heard a problem statement of there's not enough providers, and maybe Teresa, that your solution there, that who the providers are, could help with that one.
Okay. It's on the list.
And then when workers can't get into a provider, if there's not enough, I mean, is that a true statement? How do we address that? What can we get from that? Not enough providers and they can't get into the provider. I heard that's a common theme. So it's definitely a problem if they can't get in. So what can we do there? And this one was interesting to me is the workers can't afford to take off work with their appointments because either an all or nothing in the day. That was really interesting, and I'd like to hear potential solutions for that. That seems like a real problem. Obviously if their wage replacement income, they need to work for that, but they can't then go to the doctor because it's an all or nothing day. So any solutions that anyone could provide on that would be really helpful for me, because I see that as a major problem as well. That's kind of what I was tracking. Matt, what do you think?
Yeah, and the other, it did sound like maybe there's some discrepancies. It's like what the providers are doing with the releasing of different conditions of whether or not the patient can work. So I was a little bit confused about that, so I could seek some clarity on around not being able to get into a provider, but then it sounds like the insurance or the employers are wanting to, are feeling that it seemed like there was kind of a catch-22. The worker wants to get back to work or get back to more of work, and then there's a gap of the provider being able to release them without seeing them, but then they can't get in to see them. So I don't know if there's it doesn't seem like that's easily quantified, but it'd be interesting to hear more about that, or see if there's any kind of metrics to see that. And I would also be interested in metrics about, and I know I've mentioned it before, just if there's data on, how many bug letters are sent out that don't work. It seems like those would all be tracked in some form or coded somewhere that maybe folks could pull up. It doesn't need to be super accurate, but just so we can have an idea of how significant the issue is. That's about all I have.
And then I heard some potential solution, approaches to take, and anything that we could address, like we just talked about, for an all or nothing day of getting into care. That, I think, that should definitely be part of the solution. I like that if someone could think through, or the stakeholders could think through what that would look like. I also heard some incentivizing patients to make appointments versus the penalty approach. And then the continuation of care, maybe engagement not only with the attending physician. I don't know what that would look like, but I think that was interesting. And then I heard to take down barriers, just as an overarching theme on that as well.
With the MCOs, if they could maybe bring an RN care manager or somehow describe what that looks like in their process, because I would be curious if that is something to differentiate their experience. And as far as that incentivizing, I did read like a meta-analysis of 19,000 patients over like 3 decades, and it noted that support was a big issue with compliance to medical care. And then when it started to kind of break down that support, and it looked at like practical supports, childcare, transportation, things like that were the big supports that help people. Less so they broke down the supports in a few different categories, but like less so than emotional type supports. They were saying like what they saw that the impact of patients was practical. So I'd be interested in kind of trying to dig into that, or what, along with the lines of the barriers, or what are some of the supports that could eliminate those barriers.
Okay, I needed to make sure I wrote down the complete thought so before I lost it. Okay. Is there anything else to add before we close the meeting? Okay, I think I've got my to-do list here. Matt and Sarah, I'll work with WCD and folks, and I'll get something over to you. May not be until next week, depending on people's availability for me to ask questions and such tomorrow, but we'll get something to you as soon as we can. For those in the audience, we will get and finalize the next meeting date and get the agenda posted as quickly as we can. But in the meantime, if you have any questions, don't hesitate, feel free to reach out to me on that. Sarah, Matt, any closing thoughts or anything else for the good of the order?
I appreciate the open nature in which we are all coming to the table, and what the problem statement really is and how we can be creative on a solution. I know there's maybe got off on a little bit of a wrong foot, but it seems like we're back on track, and I appreciate everyone's willingness to work through it with us.
Likewise, thank you.
Okay, with that, we will see you sometime on the week of September 12th. Not sooner. Thanks, everybody.
Recording stopped.